Yes, indeed, another win for the Second Amendment, this time in Nashville, Tennessee. I want to talk about this win in favor of the Second Amendment, but most importantly, I want to discuss a doctrine that you may not be familiar with. It's called the Unconstitutional Conditions Doctrine, and this may very well affect your Second Amendment rights, so I want you to know about it. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. And please encourage other people to watch this channel. We're really working hard to try to grow our subscriber base to the point where I'm now even on Twitter. Okay, folks, here's the story. In a case called Columbia Housing in Nashville, Tennessee versus Kinsley Braden, we had a Second Amendment win. It's a very interesting case. These cases I'm about to describe have occurred throughout American life, but now they're occurring more often, and they continue as a general matter to be wins for the Second Amendment. This is a case where Kinsley Braden wanted to move into, and did indeed move into, a public housing project. It became his home. That's where he rented his home from. But the housing project was owned by the government. It was owned by, I believe, the state of Tennessee or one of the cities there, but it was owned by the government. It was a state actor, which means the Constitution applies to it, of course. So Mr. Braden signed a lease voluntarily. There's no debate he did it voluntarily. He signed a lease to move into this public housing project. In the lease, it specifically said no guns allowed. You can't bring weapons or guns onto the property. But he still signed the lease. After signing the lease, about 2 years into the leasehold, the landlord found out that Mr. Braden had a gun on the property. And so the landlord sued to kick Mr. Braden out of his home. Mr. Braden wisely asserted that he had a Second Amendment right to keep and bear arms, and under the Heller decision and the McDonald decision, he had a right to have a loaded gun in his home for self-defense purposes. And because he lived in this apartment, guess what? Well, that was his home. And under Heller, he could have a gun. So what happened? Well, the court said, guess what? Mr. Braden lives in the public housing. This is his home. He has a right under Heller. The public housing authority is owned by the government, and therefore the Second Amendment applies, and therefore he has a right to have the gun in the home. The court went on and talked about something I want you to know about, because it's very important to know about. It's called the Unconstitutional Conditions Doctrine. Now, what this is the government is not legally allowed to tell you that in order to get a public benefit, you have to waive your constitutional rights in exchange for some sort of, again, discretionary benefit. So, for example, the government cannot say, you have to give up your right to First Amendment, you have to give up your right to the Second Amendment, you have to give up your right to whatever in exchange for a job or Social Security or any of these things. It's called the Unconstitutional Condition Doctrine. And the court applied that here, saying that you cannot tell Mr. Braden that he has to give up his right to keep and bear arms under the Second Amendment simply because he wants to move into public housing and you're willing to offer it to him. So therefore, the court rejected the government, basically the housing project's argument that they could kick Mr. Braden out. So the court says, no way, no how. They also had a discussion in this case about what is a sensitive place. And you know, a sensitive place is it's a euphemism for a government-imposed gun-free zone. And they discussed whether or not public housing could be a sensitive place. And the court ultimately said that because people live there, it really cannot be. Again, I want to mention one thing about a sensitive place. I don't think I've made it clear in the past. We should do more videos on the sensitive places, but specifically keep in mind that the Supreme Court said that there are certain types of things that can be sensitive places, government-mandated gun-free zones. They're all based on government. They're the courthouses, the polling places, legislative chambers, government buildings, and schools, presumably public schools. Here's the key thing. I want you to understand this. Just because the Supreme Court says they can be sensitive places doesn't mean they're automatically sensitive places. So what I mean by this is, it seems to me that the proper way to interpret the sensitive places doctrine is if one of those items are involved, that is necessary, meaning in order for the government to be able to ban guns, it's a necessary condition before they can even consider it. that it be somehow relating to a government function. But that alone doesn't mean it's sufficient for it to be a sensitive place. So what I mean by that is just because the post office or the post office parking lot is a government-owned entity doesn't in and of itself make it a sensitive place as I see it. Think of an example, an even more egregious example. Think about, for example, public parks. Well, public parks are owned by the government, right? It's a government function, but it's hardly a sensitive place because often they have tens of thousands of acres and no protection. So again, we'll talk in greater detail about sensitive places, but all for the purposes of this case of Columbia Housing versus Kinsley Braden. Mr. Braden, the court says, yeah, this is a housing complex. People live here. I don't really see this as a sensitive place based on American history, so I'm not going to go there. But I do want to read some really good language here from the court down there in Tennessee. This is a state court, by the way, in Tennessee. It wasn't a federal court, and this is what the judge wrote. Because Columbia Housing, the public housing structure, because Columbia Housing is a government entity acting as a landlord of property it owns, it must establish that its leasehold restrictions on firearms is consistent with the nation's historical tradition of firearm regulation. And remember, we keep going back to this. The idea being that now under the Bruin standard, in order for a modern-day gun control to be upheld, they have to show there's some historical analogy, a historically analogous law in 1791 when the Second Amendment went into effect. And the court continues to say, we find that the government here has failed to do so. Moreover, because broad-reaching prohibitions on possession of handguns in the home for self-defense are historically unprecedented, we hold that the public housing facilities' overly broad prohibition against handguns in Mr. Braden's home is an unconstitutional condition and therefore will not be upheld and enforced. And they let Mr. Braden continue to live in his home. They did not evict him. And congratulations for Mr. Braden for upholding the Second Amendment and for protecting your rights. We need more people like you fighting. And again, I'm very happy about this. Okay, so again, bottom line is keep this in mind that when the government asks you or forces you to give up a constitutional right in exchange for a discretionary benefit, as a general matter, that's not allowed under the Unconstitutional Conditions Doctrine. Here's a perfect example of that where they said, Mr. Braden, if you want to live in a public housing, you have to sign this lease that says no weapons allowed and effectively waive your Second Amendment rights. In this case, the Tennessee court says no can do. That's not how it works. That's an unconstitutional condition of being able to benefit from public housing. And, you don't have to waive your Second Amendment rights, right, just because you want to live in public housing. That's not how it works any more than we would deny you the right to vote or the right to free speech if you wanted to live into public housing as well. Okay, hope you learned a little bit something. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.